Hi, everyone. Ready? All right, let's start. Are we ready? Good. Let's start. I hope everyone had a nice weekend. Any questions on the 14th Amendment, on Slaughterhouse, on Bradwell, on privileges or immunities? Any questions on those areas? No? Okay. So today's class moves a little bit backwards. We discussed almost a month ago the cases of Hearts of Atlanta and Katzenbach and McClung. These were the cases where Congress used its commerce power to eradicate various forms of discrimination. And at the time, we said the reason why the court used the Commerce Clause and not the 14th Amendment was because of the civil rights cases. About a week ago, we did the civil rights cases. And the civil rights cases tried to determine whether Congress could eradicate discrimination in various places of public accommodation, like restaurants and hotels. And the Supreme Court, in the civil rights case, said, no, you cannot. The 14th Amendment, by its very terms, only reaches state action. And private forms of discrimination are not state action. So that case, whether you realize it or not, was premised on Section 5 of the 14th Amendment. And Section 5 of the 14th Amendment allows Congress to enforce, by appropriate legislation, the provisions of the 14th Amendment. So what the court held was that Section 5 could not be used to regulate private conduct. Private conduct. Today, we will discuss a different aspect of Section 5. The question is whether Section 5 can be used to intrude on a state's sovereignty. And specifically, whether Congress can allow a state to be sued, right? Our discussions in both Boerne v. Flores and United States v. Morrison consider whether Congress can waive a state's sovereign immunity, or abrogate, if you want a big word, whether Congress can abrogate or waive a state's sovereign immunity. That will be the second half of the class. But before we can get to whether Congress can waive a state's sovereign immunity, we have to discuss what is sovereign immunity. And to discuss what sovereign immunity means, we must start with one of the first major Supreme Court cases in American history, the case of Chisholm against Georgia, followed shortly thereafter by the ratification of the 11th Amendment. And then, nearly 100 years later, the case of Hans against Louisiana. These three instances, Chisholm, the 11th Amendment, and Hans, decide what our current law about sovereign immunity means. These are very confusing precedents. They don't necessarily make sense, nor do they reconcile with the text of the Constitution. And if you ever want to get a law professor in a tizzy, ask him whether he thinks Hans v. Louisiana is correct. They'll say no. But these are the cases that gave rise to the doctrine of sovereign immunity. And we will discuss later in class whether Congress has the authority to waive or abrogate that immunity. Okay. So any questions before we begin? We'll get back to the 14th Amendment, I promise, but we need to first discuss the 11th. And I include this topic deliberately. The reason why is that virtually all of you, or none of you, will ever take federal courts. Federal courts is an important class of how to litigate in federal court. Now you may say, oh, I don't want to be a federal lawyer. I want to be in state court. I want to be in Texas. Fair enough. But just as important as knowing how to get into federal court is knowing how to keep your client out of federal court. You've learned about amount of controversy, right? Well, knowing how to keep your amount of controversy under $75 grand is one way of keeping out of federal court. There are other ways of keeping your client out of federal court when it's not conducive to his or her case. So I encourage you to take federal courts. You won't, but I encourage you anyway. One of the most important aspects of federal courts is the doctrine of sovereign immunity. You say, what do I need to know about sovereign immunity? Well, what if your client's ever injured by a state official? What if your client is denied an education for his child by the state? There are very elaborate doctrines of how you go about suing the state, when you can seek injunctive relief, when you can seek damages against the state. It's a very intricate balance. And if you ever want to do any sort of tort or personal injury law or any sort of civil rights litigation, you need to know sovereign immunity. So this is a useful topic, totally apart from ConLaw. Okay, any questions? All right, let's begin. So I want to start with Article 3 of the Constitution. Just open up your constitutions, please. Oh, I have a different one, but it's the same thing. So Article 3, Section 2, just so much you have the page number. I have a different one today. I keep one of these in my suit jacket, and over to the dry cleaner, I always have to take one out and put the wrong one back in. The cleaners always say, "Is that your passport?" I'm like, well, it's a passport to liberty, perhaps, but it's not. It's not my passport to leave the country. No, indeed, the U.S. passport has a shot of the Constitution, and so it's in the same ballpark. So Article 3, Section 2, we've discussed this when we did Marbury, right? And you recall the black letter outline of Marbury is that Congress cannot expand the original jurisdiction of the Supreme Court. We already studied that. But there are other aspects where Congress defines the jurisdiction of the lower courts. So it says in Article 3, Section 2, the judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties, which shall be made under authority, ... to controversies between two or more states. Okay. To controversies between a citizen of citizens and another state. There's also, if you keep reading down, it says to controversies between citizens of different states. Now, you study this in civil procedure. The entire basis of why federal courts have diversity jurisdiction between citizens of other states is right here in the Constitution. I promise you, you didn't learn that. If you did, good for you. But it comes right here from Article 3. What about these other grants of jurisdiction to controversies between two states? Well, that would seem to suggest that if State A files a lawsuit against State B, maybe over a boundary or something, that can be brought in federal court. And with this next one, the one I highlighted here in pink, right? Controversies between a state and citizens of another state. That would seem to suggest, right? That would seem to suggest that a state could sue a citizen of a foreign state in court. It would also seem to suggest that a citizen of a foreign state could sue a state. So that is, a citizen of Georgia can sue South Carolina. And this raises a very, very deep question about federal jurisprudence that you learned about in Erie, but probably never thought much about. When you go to federal court and you file a lawsuit, you can bring a state cause of action, right? No problem. If there's a breach of contract case under state law, and I'm in Georgia and you're in South Carolina, we can sue each other in federal court. No one even thought twice about that, right? Now you learn about in Erie which law you apply. That's all well and good. But the Constitution only provides for jurisdiction, right? The Constitution only allows you to bring that claim in court. Does the Constitution say which law will be applied? And the answer to that question is no. This is why you study in CivPro the case of Swift against Tyson, right? That was a doctrine for many years. The development of federal common law. The idea that federal judges could make a common law about contracts or tort, whatever it happened to be, and then in diversity cases, it'll be understood that that is the law. This doctrine was repudiated by Erie, right? And what did Erie say? Erie said that when a court's sitting in diversity, right? Diversity right here from Section 3, or Article 3. They apply the law of the forum state. Okay, again, neither Swift nor Tyson nor Erie is compelled by the Constitution. The Constitution is silent about the substantive law to be applied. Right? But Erie settled as black letter law. I'm not telling you Erie's wrong. It probably is, but I'm not saying Erie's wrong. They weren't always right. But that's the law today for many years. Forum shopping, all that stuff, that's not the Constitution. Convenience, doesn't, all that stuff matters. So, this raises then an important question. If federal courts are supposed to be applying the laws of the forum state, or indeed they're applying some sort of federal common law, either way, under the common law, could a state be sued? This raises the issue of Chisholm. Long before there was a constitution, there was a king. King George, in fact. And the king could do no wrong. The king could do no wrong. In England, if you had a problem with the king, you could petition your grievances. That's what that means, by the way, right? The First Amendment. You could literally petition the king for your grievance, for what you have a grievance with him, and then hope that maybe he addresses your question or maybe not. But the notion that you could sue the king was a joke. You couldn't bring the king to court. There was no jurisdiction to bring the king to court. So then what happened upon independence? We often say before that the executive power of the king went from England to the states, that the states embraced whatever executive power the king had. All right? So under the Declaration of Independence and under the Articles of Confederation, it was almost certainly true that the states embraced this power, this sovereignty, this ability to not be sued that the king had. Okay, they had that. But then when we get to the Constitution, there's a question. We said before that when the states, and really the people of the states, ratified the Constitution, they relinquished their power. The states and the people gave to the central government this new authority. There are certain things that the states could do before that they could not do now. And we think of the big things like, regulating interstate commerce, declaring war, big things that the states maybe could do before, but they gave that power up upon ratification. Which brings us to this. When the framers of the Constitution added Article 3, Section 2, and they expressly said that states can be the subject of suit in federal courts, were the states giving up that sovereignty? Oh, that's the question. When the framers of the Constitution and the people ratified Article 3, Section 2, were they giving up that right not to be sued that they got from the King of England? Or was this merely a statement of situations where the courts had jurisdiction? That is, Erie. Was this just a grant of jurisdiction for lawsuits, or was it also a substantive change of the law? Was this a substantive change in creating a federal common law to allow the states to be sued in federal court? This was the question of what this section of the Constitution did. Right? Was Article 3 the states relinquishing their own sovereignty so they could be sued? It didn't get that much, right? Everyone with me so far. This was the master question of what Article 3 did. Because the states gave up a lot of their autonomy, right? They gave up a lot of power. Did they also give up the right not to be sued? And this was the question which was addressed in Chisholm, but was not really resolved until Hans v. Louisiana over 100 years later, or about 100 years later. Okay. All right. Everyone with me so far? Okay, so where did I finish up last time? Okay, thank you, Shelby. Appreciate it. Is that right?
I think so.
Okay.
Did you ask questions?
I don't remember.
Okay.
I have 2 classes. I'm in the same exact room, so it's actually impossible for me to remember. I try giving up. They always put me in the same room twice, so it's like the same rows and basically the same number of students. So I have this thing. Okay, Shelby. So what were the facts in Chisholm? The facts are pretty straightforward. Chisholm v. Georgia. The first case. 558. I'm sorry, 558. What are the facts there?
So, Chisholm, he practiced in the state.
Where did Chisholm live?
Okay, South Carolina.
Yes, okay. So Chisholm lived in South Carolina. And who did he sue, Shelby?
The state of Georgia.
Okay, good. So Chisholm sued Georgia. And what was the suit over?
A debt that dated back to the Revolutionary War.
Good. Okay, let me pause you right there. Much of early America was defined by arguing over debt. During the Revolutionary War, a lot of the states issued bonds, trying to raise money for the war. And unsurprisingly, a lot of those states never paid those back. The Constitution has what's called a contracts clause. We discussed this probably a month ago. And under the contracts clause, states cannot violate contracts. They're bound to keep contracts. And you would think that if the Constitution guarantees the right of contract and a state violates a contract, then you can go to court and sue, right, under Article 3, Section 2. Article 3, Section 2 says, when there's a controversy between a state and a citizen of another state. Well, here you have Chisholm of South Carolina suing Georgia over this violation of his contract. He's trying to recover the debt that's being owed. Okay. So, Cindy, the first question is this. I ask a question like this. Does the mere fact that the Constitution says there's jurisdiction for this claim mean that they actually have the power to adjudicate this? Why not? Does the mere fact that the Constitution says, just textually for a minute, a dispute between a state and the citizens of another state, does that necessarily mean that Chisholm can sue Georgia? Is that the only way to read it? No. Is that the only way of reading that provision of the Constitution? Here we have it says, the controversy between a state and citizens of another state is the only way to read that Chisholm is suing Georgia. That's the only way to read that. How could you also read it? What's the other way you can read that sentence? Think. What's another way of reading that would avoid the thorny issues we have here? You know what I'm getting at?
Georgia suing.
Okay, good. So there's 2 ways we can read that sentence, right? The citizen sues the state, or the state sues the citizen. So before we get too deep into it, textually, right? It's either way. You can read either way. So Georgia comes and says, wait a minute. All this says is that the state can sue the citizen, right? But does it have to be that way, right? Why can't it run both ways? What makes this decision hard, right, is the way it's laid out. So John Marshall, for all the bad things he did one good thing. Actually, I don't know if this is good, but it's helpful. Before John Marshall, you never had a majority opinion. That wasn't a thing. You had what was called seriatim. Help you. Seriatim, which basically means each separate judge in the court would write his own opinion. None labeled majority, none labeled dissent. And it will be up to you to figure out which was the majority opinion. You think briefing cases is hard when there's only 2 opinions? Try when there are 5. So indeed, what's odd about this case is that the first opinion that comes up from Justice Iredell is really a dissent. The other 4 opinions are more or less the majority. But each takes a different approach. Okay. Now we'll start with Justice Iredell. And Justice Iredell's opinion is important because it is the one that really resonated with the 11th Amendment. Right? This is what people latched onto. So, Sean, tell me, sir, what was Justice Iredell's point?
He said that we can't just make up stuff on our own, ourselves, that we have to look at history.
Good.
And history was that wrong.
Yeah. So Iredell basically said, Iredell was basically Justice Brandeis in Erie Railroad, if you think about it, if I can make the analogy. Okay. Iredell said, we cannot create this brand new federal common law allowing a citizen to sue a state. We can't make up this federal common law. We need to look at the common law of the states as it's been in existence for the 5 years of our country and beforehand, right? We can't make up this new federal common law, which allows a sovereign to be sued. For Justice Iredell, whatever sovereignty the king had went to the states. And he says we should be very careful not to read the single sentence in the Constitution as quietly eliminating this entire doctrine of sovereignty, right? If the framers of the Constitution wanted the states to give up their power, they would have done so very clearly, right? They would not have done it casually in a grant of jurisdiction. To Justice Iredell, the only reason why this clause is there is to work against the backdrop of history. The only reason why this clause is there is to say a state, if it so chooses, can sue a citizen in federal court, not the other way around. There was no new law here, and as Justice Brandeis said in Erie, it's not for judges to create this federal common law. We should reserve to what the states. You never saw Erie that way, did you? No. This goes back to Erie. The linkage is actually very tight. Whenever I mention Erie, kids get this chill across them, but it's actually probably the most important case of the 20th century. It's up there with like Brown and Youngstown. It was a really important case. Okay, so I'm going to get Justice Iredell. Any questions on Iredell? Okay. Now the other justices take a different perspective, and we can go through them in a minute. But what the other justices are basically saying is, we fought a war, so we wouldn't have a king anymore. We ratified a constitution to get rid of this idea of the sovereignty, right? John, tell me, sir, under our constitution, who is sovereign?
I say not the state because the people voted to ratify.
What are the first 3 words of the Constitution? We the people. The people. So the other judges rejected this idea that the states have this sort of special sovereignty. They said the sovereignty of the United States resides in the people themselves, right? Justice Blair said, European law is not relevant. I love this quote. The Constitution is the only fountain from which I shall draw, the only authority to which I shall appeal. Blair says the states gave up their sovereignty by adopting the Constitution. To Justice Blair, this sentence was basically a waiver of their sovereignty, a permanent waiver of their sovereignty. They gave that up. They had it before Revolution. They gave it up. The next decision by Justice Wilson, and by the way, Justice Wilson is one of the most underappreciated framer of the Constitution. He was from Pennsylvania. He was a brilliant man. He unfortunately died early. He had an illness. He was in debt. It was not a good story. But he was a brilliant framer of the Constitution. So he was there, right? If you can imagine this, right? You have people who are actually at the Constitutional Convention being called upon to interpret what the Constitution means. It's stunning when you think about it. And even then, not even, 5 years after ratification or 5 years after the convention, they're still arguing over it. So we're in good company today. Justice Wilson said that the sovereign is the people. He says the majesty of the people are the first personages introduced. In terms of the text of the Constitution, he says, when one state wants to sue another, they both have to be amenable to the suit. And for this clause, it's only when a state sues a foreign citizen. Okay. Justice Cushing said much the same. The state can only be made the plaintiff. They cannot be the defendant. And then we have Chief Justice John Jay. John Jay was one of the authors of The Federalist. He was the governor of New York. He was the first Chief Justice of the United States, a very influential figure in American history, who makes much the same point. And in fact, he makes a position that's quite anti-federalist, if I can use the phrase. He rejects the notion of state sovereignty altogether. He rejects it altogether. Query, though, that throughout all this, they never discussed the idea that you can't sue the United States. All right? All this discussion of how you can't sue a state, you can't sue the United States either. That the United States has sovereign immunity. So throughout this entire discussion that the states don't have the sovereignty, oh, by the way, you can't sue the United States in federal court. You notice that? Nothing. It's an interesting historical footnote. So everyone get Chisholm, right? The opinion is not particularly long, but the general gist is 4 of the 5 judges in the court all said that sovereignty resides in the people and that the Constitution represented a waiver of whatever sovereignty the states had, and you could then sue a foreign state in federal court. You couldn't sue your own state, but you could sue a foreign state in federal court. What they said. Any questions on Chisholm? No? No? Okay, I'll move on. What happened after Chisholm is remarkable. You know, again, we're talking, was it 1792? We are 3 years after the ratification of the Constitution. We are basically 1 year after the ratification of the Bill of Rights. We are in the primordial soup of our republic, if I can use that phrase. And the people were outraged by this decision. They were outraged. They said, how could it be? How could it be that a state can be hauled into federal court and sued by some foreigner? Right? I mean, today we don't think much about a person in Georgia and a person in South Carolina, but back then that was a big deal. To have a South Carolinian, a foreigner, an interloper, right, suing the state of Georgia, the majestic state of Georgia, was considered an insult. Can you imagine if a Yankee sued Georgia? We've had a civil war 80 years earlier. This was a big deal. So almost immediately after this decision was rendered, Congress proposed an amendment, what would become the 11th Amendment. Okay. It was ratified by the people almost immediately. Now, before we get to the actual text of the 11th Amendment, Alexa, what do you think the significance was when the Supreme Court said states don't have sovereignty, and then almost immediately the people ratified a constitutional amendment saying, oh, yes, they do? What do we make of that? How do we understand whether Chisholm was right or wrong? What does that? What insights does that give us? Why do you think it's wrong? Oh, what a good point, right? So this is a classic example, right, of the Supreme Court does not have a monopoly in interpreting the Constitution. They made their ruling, the people disagreed, and they overturned it. It doesn't happen very often. It's happened a couple times. But the court made a ruling. They said, here's how we're interpreting the Constitution. The people disagreed. And ultimately, the people are who everything's accountable to, the sovereign people. This is the cornerstone of a republic. So I'll note briefly, in Hans v. Louisiana, Justice Harlan, my man, right? He concurred. And he said, I agree with the majority. And oh, by the way, Chisholm was correctly decided. More likely than not, Chisholm was correctly decided. This is, ask a law professor whether they think Chisholm was right. They'll argue with you for months. I think Chisholm was right. I think it was actually a correct statement that after the independence, the state shook off this sovereignty notion. We were sovereigns as people. I think that's a better argument. I think John Jay and James Wilson knew what they were talking about. But that doesn't matter, right? Because the ratification of the amendment rejected that. Our Constitution can be changed. This is a foreign thought to this class where every single thing we study is changed by judges. We have a process. It's called Article 5. We can have amendments. Our Constitution, as much as I love this document, is not sacrosanct, right? It can be changed. And there's absolutely nothing wrong with changing by amendment. If 3/4 of the people in the states want to repeal something that I like, well, then whatever. I mean, I had a reporter call me about a month ago, ask me what would I think if there was an attempt to repeal the Second Amendment. I'm like, well, I think you'll never get 3/4 of the states to do it. In fact, we're actually really close to having 3/4 of the states to strengthen the right to bear arms. But I said, if that's what happens, if my fellow brothers and sisters want to repeal the Second Amendment, then what am I to say? I think it's probably a stupid idea, but that's how our system works. So even if Chisholm was right and they amended the Constitution in a way that was probably misguided, that is what happens, and that's our new law. Okay. Any questions on that? I'll go on to the 11th Amendment in a minute. And that brings us to the 11th Amendment. Okay. This is an amendment that has, again, perplexed lawyers now for nearly 200 and something years. It says, the judicial power of the United States shall not be construed to extend to any suit in law or equity commenced or prosecuted against one of the United States by citizens of another state or citizens or subjects of any foreign state. So I want you to focus on the language of the amendment very, very, very carefully. You'll recall in Article 3, it says, the judicial power shall extend to controversy between a state and citizens of another state. Keep that in your mind. The judicial power shall extend. What does this say? The judicial power of the United States shall not be construed to extend, right? Article 3 said, the judicial power shall extend. Here, it shall not extend. What was this doing? Okay. At a minimum, the 11th Amendment withdrew jurisdiction from the federal courts. It withdrew jurisdiction from the federal courts. Article 3 extended jurisdiction. The 11th Amendment says it shall not extend. Article 3 withdrew jurisdiction from the federal courts. Okay. And which type of jurisdiction did it withdraw? Suits prosecuted against a state by a citizen of another state. It withdrew the jurisdiction where the plaintiff was a citizen of South Carolina and the defendant was the state of Georgia. It withdrew that from the federal court's jurisdiction. Everyone with me so far? So on that narrow ground, you can say that the 11th Amendment reversed Chisholm, right? It rescinded Chisholm. Chisholm said you can have jurisdiction where South Carolina citizen sues Georgia. The 11th Amendment says, no, you can't have jurisdiction there. Everyone with me? But did it do more than that? Okay. If you'll recall, Justice Iredell's dissent in Chisholm created federal common law. Justice Iredell's dissent in Chisholm, like Swift v. Tyson after it, created federal common law. He said, the law of the United States is that a state cannot be sued. The law of the United States is that a state cannot be sued, right? That's federal common law. That's nowhere in the Constitution. No state, right? It wasn't a state law. It says federal common law, a state cannot be sued in federal court. The question is this. Did the 11th Amendment embrace all of Justice Iredell's dissent? Did the 11th Amendment also embrace the notion that as a matter of federal law, states cannot be sued anywhere? And you may say, Josh, why does this even matter, right? A citizen of South Carolina has no jurisdiction to sue Georgia. But the framing of the words of this amendment allow a citizen of Louisiana to sue the state of Louisiana. Think about this for a second, right? All this says, right? All this says is the judicial power should not be extended against a citizen of one state and a foreign state. It says absolutely nothing about a citizen of Louisiana suing the state of Louisiana. It says nothing about it. Indeed, going back to Article 3, you studied in civil procedure federal question jurisdiction, right? Remember this? Federal question jurisdiction doesn't depend upon who the parties are. You can have non-diverse plaintiffs with a federal case, federal question, right? Remember this? So believe it or not, for the first 100 years of our republic, there was no federal question jurisdiction. It was all diversity. But then in the 1890s, it was 1880, I'm sorry, yeah, 1890, Congress created federal question jurisdiction. So now, you could sue a state, right? Morgan, tell me please, what were the facts then in Hans v. Louisiana? You're sensing a pattern here, right? The reason why people are suing states is because the states aren't paying up their debt. Now, Christine, why couldn't Hans just sue Louisiana in Louisiana state court? Right? There's a contract, there's a breach. Why can't he walk into state court in New Orleans and file suit? I'm sorry, louder. The 11th Amendment only concerns federal court, right? The power of the United States courts. Why could he not sue in the state court? No. Why can a state not be sued in its own court system? Christine, what was the principle that made Georgia so angry in the first place? Why was Georgia so angry in the first place? Yeah, why were they so angry? It wasn't peachy. Why was Georgia so angry in the first place? You know, Delarm? Yeah, but why would Louisiana mind if its own citizen was suing it? Why is that a problem? Why couldn't Hans have just walked into a state court in New Orleans and filed suit? Anyone know? Yeah.
Wouldn't they have to consent?
Yes. Exactly right. Exactly right. The principle of sovereignty, right, is you cannot be sued without your own consent. Unless you consent, you can't be sued. Louisiana and Georgia never consented to be sued. So if you walked into a New Orleans court and said, "Hey, I want to sue the state of the state of Louisiana," they'd laugh you out of court. They'd say, "Get lost, scram." So now we have federal question jurisdiction. And Hans says, "Wait a minute, you owe me $87,000, and I convert that to present day dollars over $2 million. So we're talking about a pretty good chunk of change that was owed to Mr. Hans. So Hans said, "Okay, awesome. I have a federal question. You're violating the contracts clause. I'm going to federal court, and I'm going to sue my own state." Now, Sydney, is there anything in the text of the 11th Amendment that prohibits Hans from suing his home state? Why not? Another state. Okay. So the actual text of the 11th Amendment in no way limits this. Because there's federal question jurisdiction under Article 3, there's federal question jurisdiction, Hans can drag the state into federal court. Okay. And this is where Justice Iredell comes into play. Iredell's thesis was that as a matter of federal common law, right, that states had this sovereignty, independent of anything in the Constitution, that the states had this sovereignty pre-existing the Constitution, and they maintained it. So Randall, what does the court hold here, right? What does the court hold here? Can Hans sue Louisiana in federal court?
No.
Why not?
So they look for the consent of the Congress,
Okay.
consent of the drafting of the 11th Amendment. They
Good.
also talk about the acts of Congress, the judiciary acts that
Good.
confer concurrent jurisdiction between federal and state courts, and if that jurisdiction was concurrent, then it wouldn't have imposed any higher ability for federal courts to have jurisdiction over cases that the states didn't already.
Excellent. Excellent answer. So I want to take, you said a couple of really good things. I want to break it down. Take them one at a time. So the last thing he said, which is where I'll start, is that the federal question statute said that the state courts and the federal courts will have concurrent jurisdiction. Concurrent jurisdiction. It goes without saying that in a state court in Louisiana, you cannot file suit against the state. So from this, the court says, well, we'll assume the same rules apply in the federal courts. Okay? But this isn't really the law of the form, right? This is not Erie. This is Swift. The broader point he makes is, as a matter of federal constitutional law, as a matter of federal common law, states have sovereignty, and they cannot be sued without their consent. The actual text of the 11th Amendment doesn't matter. This is what's actually going on here. It's as if the 11th Amendment doesn't matter. What he's basically saying is that Chisholm was wrong, and the 11th Amendment makes no difference. That the Constitution itself guarantees the sovereignty, and nothing in the 11th Amendment affects that. So even though the 11th Amendment would then be helpful for suing a foreign state, it's not necessary. Effectively, it doesn't matter what the 11th Amendment says because this notion of sovereignty exists. And because this notion of sovereignty exists as a matter of federal common law, no state can be sued by anyone without their consent. Right? A state cannot be dragged into court without their consent under any circumstance. Everyone gets that much. It's almost as if the 11th Amendment doesn't matter. It's irrelevant because it's a matter of federal common law. As a matter of federal constitutional law, the states are supreme and they cannot be sued. The court also has another argument saying it would be very weird if Hans could sue his own state, but a foreigner couldn't. Right? Would that make much sense? Would that make any sense at all? So any questions on the majority opinion in Hans? It effectively stands for the proposition that Justice Iredell was right, that at the time of the ratification of the Constitution, the states were sovereign and they could not be sued. And regardless of whether Congress tries to give jurisdiction over these claims, because there's no substantive law to apply to allow the suit, there's a lack of jurisdiction and it must be dismissed. I want to get that. Yes, sir.
At the end of the opinion, they say that while a state can't be compelled to sue, any law that they pass that bridges a contractual obligation is void. So were they don't clearly say it, but did they hold against him in terms of his ability?
They dismiss it for lack of jurisdiction. There's no jurisdiction. So this raises a question, right? If the state violates the Constitution and there's no court to hear it, does it make a sound? Right?
Exactly.
If the state breached the contract with Mr. Hans and there's no court to hear it, does it even make a sound? This is, I'll get to you in a second, Zach. This is the question of the day. What's the point of having all these limitations against states if you can't sue them in court over it, right? If a state can just breach every contract, what's the point? This is what Hans created. This is why Hans is a civil rights lawyer's worst friend. Because you cannot sue for damages a state without their permission. Under the Constitution, you cannot sue a state without the permission. Except where Congress lets you. You see, the states are not the only people who can waive their sovereignty. Under the 14th Amendment, and under Section 5 of the 14th Amendment, Congress can waive a state's sovereignty for them. This was the revolution affected by Section 5. Before the 14th Amendment, a state's sovereignty could only be waived by the state. But after the ratification of the 14th Amendment, now Congress had the power to waive a state's sovereignty and let you sue them in federal court or even in their own state courts.
Okay, this kind of doesn't directly pertain, but what if it's not so clear where the plaintiff's domicile is? So it's like you kind of live between two states and you sue in one.
Well, now it doesn't matter because under Hans, it's irrelevant. You can't sue any state.
Okay.
But again, that raises odd points. That if you move, like that's saying, well, I can't sue a state. I'm going to move to the state, then I'm going to sue. Right? But the entire principle of sovereignty is defeated by U-Haul truck. Right? If you move, you can defeat sovereignty. But I want to get point I just said, Tariq.
How did this contradict Chisholm?
Chisholm, it didn't contradict Chisholm. But what it effectively said was Iredell was right. What Iredell said was that states are sovereign as a matter of federal law. Hans embraced that. And effectively Iredell was dissenting in Chisholm. So more or less embraced the Chisholm dissent by Justice Iredell. Why don't I repeat the point I made a moment ago? You can't sue a state for damages without its permission unless Congress waives their sovereignty. Congress can waive that, and you don't need the state's permission. Okay. One note, and I mentioned this briefly because it's in the reading. There's a case called Ex parte Young. Okay. Ex parte Young said was that you could sue a state official for injunctive relief. Right? You cannot sue a state for damages without permission. But under this doctrine of Ex parte Young, you can sue a state official for injunctive relief. that gets you a lot of stuff. So say if a state official is violating the Constitution, you can go to federal court and get an order telling him to stop, but you can't seek damages against him. It's not a total consolation, but it's it's something that's useful. And in fact, Justice Harlan wrote the opinion in that case, and he actually wrote the little concurring opinion in Hans because he knew this would not work, right? To make the states entirely impregnable to any sort of lawsuit would be dangerous. So at least they allowed some form of injunctive relief, like again, injunction saying stop doing this, but you can't sue for damages. Can't sue for damages. All right. Question on Hans, 11th Amendment, Chisholm. We'll move on to the other cases in a minute. No? Okay. So let's move on to the 14th Amendment. We discussed it last week, but I want to look at it now under a different light. Last week we discussed the Privileges or Immunities Clause. And we said, well, in theory at least, it was designed to ensure that states could not deprive someone of certain rights. But what happens if a state did deprive someone of those rights? Well, one way that these issues are resolved is by a lawsuit. Now, you probably didn't even think about this, but think of the case of Bradwell v. Illinois. Myra Bradwell was suing the state of Illinois. Did anyone even think about that? Right? Remember the woman who wanted to become an attorney? She was suing the state she lived in. Did that raise any 11th Amendment issues? The answer is no. And this is actually somewhat counterintuitive, but it makes sense. The 11th Amendment, right, protected this right of sovereignty. It guaranteed the state sovereignty. Subsequent, after the 11th Amendment, the 14th Amendment was ratified. The 14th Amendment took away some of that sovereignty. It waived some of that sovereignty. So the thinking was this. The Constitution said that no state shall make or enforce any law which shall abridge the privileges or immunities of citizenship. Okay. The deprivation of those rights could be resolved in court. And indeed, the Supreme Court heard the case. I think that was actually an appeal from a state court, so it's not exactly on point, but the same principle applies. But the key portion is not Section 1 of the 14th Amendment. It's Section 5. And Section 5 says that Congress shall have the power to enforce by appropriate legislation the provisions of this article. So first, we discussed last week, Section 5 gives Congress new powers. We are no longer limited to just Article 1, Section 8. We now have these new powers in the 14th Amendment. And what did the power to do? Appropriate legislation. What does it mean for legislation to be appropriate? We'll get there later. But there's some limit on what they can do here. It has to be appropriate. But the other provision is provisions of this article. What does that mean? If a state is denying someone privileges or immunities, if a state is depriving someone of equal protection of the law, if a state is depriving someone of due process of law, then Congress can step in to take action. When they say provisions of this article, they're referring back, and you can put this in your notes, they're referring to Section 1. When they say provisions of this article, they're referring back to Section 1. So if a state deprives someone of due process of law, then the Congress can pass the law prohibiting that. All right? So we saw a number of the cases which are mentioned in your book. For example, Katzenbach v. Morgan. Katzenbach v. Morgan. States imposed literacy tests. That is, in order to vote, they required someone to take a literacy test. Congress passed a law allowing people to sue to challenge that, right? A state was violating someone's right to vote under the 15th Amendment. Therefore, Congress passed a law concerning it. In the case of Oregon against Mitchell, right, there was an issue with people being denied the right to vote who were under the age of 18. Congress passed a law allowing a suit over that as well. So you have a number of cases where Congress uses this enforcement power to allow individuals to sue states. Indeed, you've studied, or hopefully you will study, something called Section 1983. Section 1983 was originally known as the Ku Klux Klan Act. By the way, it's not the Ku Klux Klan, it's the Ku Klux Klan. Apparently people are confusing that recently. It's the Ku Klux Klan Act. And the Ku Klux Klan Act allowed you to sue a state official deprived of your civil rights. So if any of you ever want to do civil rights litigation, whether it's police brutality, wrongful death, whatever it happens to be, the reason why you can sue a state police officer in federal court is because of Section 1983, the Ku Klux Klan Act, which was actually passed under Congress's enforcement powers. Congress allowed a state to be sued when they deprived you of your civil rights. Everyone with me so far? Okay. Now, all of those suits that I mentioned, right, concern things like, you know, depriving people of the right to vote, depriving someone of their life without due process of law, that is, murdering someone. It gets a little tricky, though, with the next case. The case of City of Boerne against Flores. Anyone from Boerne, Texas? You know where it is? Yeah, that's out of San Antonio, okay? So this case is actually a little bit tricky. I need to jump ahead and explain some doctrine I've discussed before. So the last, or actually the second to last day of class, will cover the First Amendment. You only get 2 days in the First Amendment, which is sad, but that's all we have for it, unfortunately. There's a special class in the First Amendment, which I encourage you to take. None of you will. You won't take federal courts either, but I will say it anyway. I don't teach it, so it's not even a plug. Okay? The First Amendment says, Congress shall make no law Congress shall make no law prohibiting the free exercise of religion. We will discuss the free exercise clause in great depth later, but let me give you a preview. In 1990, there was a case before the U.S. Supreme Court called Employment Division versus Smith. The facts of the case were like this. Mr. Smith was a Native American. Part of his religious sacrament was the use of peyote. Everyone know what this is? It's like this hallucinogenic cactus, right? It's a hallucinogen. It's a controlled substance. It's illegal, but this was something that his people have been using for, millennia or whatever it is for their various religious rituals. He was terminated from his job, and he applied for unemployment benefits. He was denied unemployment benefits because they said, look, you were fired because of drug use, right? We're not going to give you unemployment benefits for this. He sued, and this case went to the Supreme Court. What happened in that case is extremely important. What the court said was, a law saying that you can't use drugs is general, right? The law wasn't trying to single out American Indians. It wasn't trying to single out peyote users. All it said was, if you use drugs, you're not getting unemployment benefits. The court, in a very controversial 5-4 decision by Justice Scalia, said, so long as the law is general and there's not any animus, it's not singling out religion, it's constitutional. If the state wants to deprive all drug users of unemployment benefits, they can do that. They can do that. So the holding of Smith was, unless there's evidence of deliberate intentional discrimination against religious groups, the state acts lawfully. Okay, we'll do this case later in about a month or so. This decision was very unpopular. You can imagine why. Religious groups are saying, wait a minute, how can the government single us out, right? What if my religion requires me to use sacramental wine and the state prohibits alcohol? How can you use sacramental wine? By the way, During Prohibition, there were actually carve-outs for sacramental wine, so that the churches still got alcohol during federal Prohibition. It's actually a relevant fact. So there was a huge bipartisan consensus, and Congress enacted very quickly what's known as RFRA, the Religious Freedom Restoration Act, shortened as RFRA, if you can say it that way, RFRA. Or, McGruff, right? Or RFRA. Now, RFRA was this rare bill, which is almost unfathomable today. It was sponsored by Chuck Schumer in the House and Ted Kennedy in the Senate, and signed by President Clinton. It was basically unanimous in the Senate. I think like maybe 1 or 2 people voted against in the House. This was a bill that everyone loved. Now, what did RFRA do? Well, the nature of the case in Boerne was that it allowed religious groups to sue the state. It allowed these various religious groups to sue the state if there was a burden on their religious exercise. It allowed private religious groups to sue the state if their religious burden was exercised. Okay, actually, let's go. Felipe, what were then the facts in Boerne now that I gave you all the background?
So the Archbishop of San Antonio sued local authorities because tried under the
Uh-huh.
because they didn't have any alternative to end the church.
Yes, exactly. And I actually have some pictures of the church. I had a friend some years ago who visited it. If anyone's ever seen it, you can tell me about it. But it's a very, it's a beautiful church. It's an old mission style. It's small. You can see it's a very small parish. And the problem with the church was that it wasn't big enough, and they wanted to expand so they can have more people come to the service. And you think, wow, man, that's awesome, right? A church actually trying to expand. Most churches are contracting nowadays due to weak attendance. You can see it's actually quite small. So the archbishop goes to the city and says, hey, we want a permit to build to expand our church. Now, you haven't taken zoning yet, but you'll do this in Property 2 next semester. But the short answer is states have broad discretion to deny zoning permits. They don't have to give anything. And what happened was that, listen, this church is a historical site. In order to expand it, you'd have to demolish walls, right? And make it bigger. And what the government said was, we will not give you this building permit. We don't want you to damage this beautiful structure. That's really nice for the bishop. Like, listen, I want more people. Like, oh, no. You can keep the same number of people, just have them stand outside. So usually, right? Usually, if a zoning permit is denied, the answer is too bad. You can't appeal it, and if you appeal it, there's nothing going to get to you. So the church, the Archbishop Flores, he didn't sue under Texas state zoning law. Instead, he filed suit under this brand new RFRA, right? He could have sued under Texas zoning law, which were allowed to sue in court, right? Texas has waived its sovereignty in state court to be sued on limited zoning issues. But he didn't want to sue on that because he was going to lose. Instead, he sued under this new law, RFRA, right? He sued under this Religious Freedom Restoration Act. And Angela, what did Archbishop Flores claim? What was his claim under RFRA?
That it violated their rights of freedom of movement.
How? How did the zoning decision to deny him a permit violate his right to free exercise under RFRA? And but this is not a constitutional case. Be very careful. This is under the statute. What?
They didn't give them the right to expand.
But how did not giving the right to expand violate his religious liberty? How? What was the actual problem here?
It was the burden of
Yes, exactly. Perfect. What RFRA says is that the government cannot impose a substantial burden on religious exercise, okay, unless they show that there is a compelling interest and that this is a so-called least restrictive means. Don't worry too much about that part, right? We'll get to that when we do free exercise. But here, Flores claims that this imposed a substantial burden on his religious exercise. Therefore, he walked into federal court and he filed suit against the city of Flores. Now, by the way, the city of Flores is a subdivision of the state, right? Houston, Dallas, San Antonio. There's no such thing as a city. A city only exists at the pleasure of the state. If tomorrow Texas decided they want to merge Houston and Austin, they could do that, right? There's no guarantee to have a city. Every city has a charter, which is approved by the state. We don't need Austin. I mean, they can merge Houston, Katy, whatever they want, chop it up, make 2 Houstons, do whatever they want. Cities are just subdivisions of the state. You'll take the local government class later. You'll learn this more. So what they argue here, though, is that RFRA imposes a substantial burden. I'm sorry, the denial of the building permit imposes a burden. Now, Daniel, was there any evidence at all that the city of Boerne denied this permit because they hated Catholics and were singling out the Catholic Church?
No, not at all.
Was there any evidence at all that this was motivated by religious animosity or anything?
No.
So how is this case different than the peyote case, right? How is this case any different?
I mean, in the peyote case, it wasn't directed at Native Americans and their religion, and in this case, it's actually pretty much the same.
Yeah. So here's the issue. This is, again, a law of general applicability. The law in Texas zoning law is one of general applicability. It was in no way targeted at religious groups. Look, the zoning law applies to everyone. If you're in a building that's deemed a historical landmark, too bad you can't build. So under the First Amendment, the Free Exercise Clause, they had nothing. But RFRA, the statute, attempted to do more than just let people sue over the First Amendment. They could already do that. What RFRA attempted to do was restore the law before Smith. What RFRA attempted to do was to, as it says, religious freedom restoration, right? It attempted a restoration of the First Amendment as it existed before the peyote case. Everyone understand that? They tried to bring back a test from a case from the 1960s called Sherbert versus Werner. The facts in Sherbert versus Werner were like this. You had a Seventh-day Adventist. These are people who celebrate the Sabbath on Saturday, not Sunday. And he was trying to apply for unemployment benefits. And the state said to him, you know what? We found a job for you. Why don't you go work on Saturday? He says, wait, I can't work on Saturday. That's my Sabbath. That's my day of rest. And the state said to him, well, too bad. If you don't work when we tell you, we won't give you any benefits. And the Supreme Court said that that was unconstitutional, that imposes a substantial burden on his religious beliefs, that someone should not be forced to choose between their beliefs and these government benefits. Smith effectively overruled Werner. By a 5-vote majority by Justice Scalia's pen, the Seventh-day Adventist case was overruled in the peyote case. What RFRA attempted to do was to restore Sherbert versus Werner. RFRA attempted to bring back the Seventh-day Adventist case. RFRA attempted to overturn Smith. Not really, but basically they want to bring back the Seventh-day Adventist case. So the question in Flores was very significant. Congress has the power, okay, under Section 5 to enforce the provisions of this article, right? Follow me here. This is tricky. One of the provisions of Section 5 is this. Congress shall not deprive any person of life, liberty, or property without due process of law. I'm giving you a preview here. One of those liberty interests is the First Amendment. The Supreme Court has held that one of the liberty interests protected by the 14th Amendment is the right of free exercise. If you want to note, this is what's called incorporation. We'll talk about this later. But the court has held that one of the liberty interests in the 14th Amendment is the right of free exercise. So Congress can pass a law saying if the state deprives you of your free exercise rights, you can sue them. If the state passes a law that deprives you of your free exercise rights, you can sue them. Okay? This is what we call remedial legislation. Remedial. Why is it called remedial? Because it's trying to remedy a violation of the Constitution. So, you know, if a state passes a law saying that you cannot sell the Christian Bible anymore in the state, okay, Congress can pass a law saying you can sue them for violating your free exercise rights. I think that'd be an easy enough case. But what's going on here is not remedying a constitutional violation. Why? As Daniel said a minute ago, under the Peyote case, what Texas did was fine. Under the Peyote case, there's no problem with what Texas did regarding the First Amendment. RFRA, though, attempted to make the First Amendment bigger. RFRA tried to expand what the First Amendment protects. RFRA tried telling the Supreme Court, hey, you guys, you screwed up. That's not what the First Amendment means. We'll tell you what it means. Think back to Chisholm and the 11th Amendment, right? The 11th Amendment said, Chisholm said there's no state sovereignty. The 11th Amendment said, oh, yes, there is. But they did it through an amendment. They did it through an amendment. RFRA was not done through an amendment. RFRA was done through a statute. And what's the only way for Congress to change the meaning of the Constitution? An amendment. Congress cannot change the meaning of the First Amendment through a mere statute. Only the Supreme Court, right? Only the Supreme Court can change the meaning of the Constitution. Congress cannot change the meaning of the Constitution through a statute. Everyone with me? So what the court held in Boerne, and this was probably one of the significant cases of the 90s, so-called Federalism Revolution. What the court held in Boerne is that Congress cannot tell us what the First Amendment means. Only we can decide. And we decided what it meant in Smith. Congress, you can't change that. And the Section 5 powers, this power to enforce the 14th Amendment, is limited to how the court interprets the 14th Amendment. Let me say that again. Congress's powers under the 14th Amendment are limited to how the court interprets the 14th Amendment. Congress cannot take it upon itself to interpret the 14th Amendment more broadly. There are constraints. If the court says in the Peyote case, this is what the First Amendment means, that's it. Congress cannot add on to it. Congress cannot make additional rulings for the First Amendment. This is solely the province of whatever the court says. So here the court is indeed establishing its monopoly on interpreting the Constitution. The court says, if you want to change the meaning of the Constitution, go amend it. A statute will not suffice. Everyone understand that? So the court effectively holds that RFRA, as applied to the federal government, is unconstitutional. I'm sorry. RFRA as applied to the states is unconstitutional. RFRA as applied to the states is unconstitutional. That it's not up to the states, it's not up to Congress to decide how to interpret the 14th Amendment and how to interpret the First Amendment. If Congress disagrees with the court's ruling, go amend the Constitution. Do what they did in the 11th Amendment with Chisholm. So therefore, you cannot have Congress expanding the meaning of the Constitution. Everyone get that? Questions? I had an exam question maybe a year or two ago where Congress tried to expand the meaning of the Second Amendment. the court is only held to the present moment, at least, for the time being, as we may say, that the right to keep and bear arms applies in the home. And I wrote a question where Congress passed a statute saying the right to keep and bear arms applies out the home, the right to carry. And the question was whether that was constitutional. And I think the best answer was, under Boerne at least, only the court can expand the meaning of constitutional rights, not Congress. I think that's the right answer, but it's debated. So I don't get that part of the case. Questions on that? This is actually a fairly significant aspect where only the court can interpret what the 14th Amendment means. Congress cannot. I mean, it's a jarring thought if you think about it, that Congress has absolutely no role to decide what the 14th Amendment means. Yes, Felipe.
Do you think that community also the prevention of churches getting out of order or like government that they have to do with the
I'm sorry, say your question one more time.
Like you think like maybe they want to prevent churches from getting out of order?
The court?
The court, yeah.
In Boerne?
Yeah.
I think actually, if I can answer a question frankly, the decision in the Peyote case was that. In the Peyote case, you have Justice Scalia, who is known as a fairly conservative judge, ruling that we should not be giving exemptions to churches. Right? In the Peyote case, saying, listen, you want to be a Native American? Good for you, but you can't do drugs and get a government benefit. Ironically, it was the liberals in the Peyote case saying we need to give exemptions to the law for religious groups. Fast forward 20 years, and case at the court now involving the Affordable Care Act with Hobby Lobby and the Little Sisters of the Poor. And now you have mainstream Christian religions seeking exemptions from generally applicable laws based on RFRA. And you have the same liberal group saying, no, we can't give exemptions to Little Sisters of the Poor. They have to provide contraceptives to their employees. So there's been this almost this surreal reversal where at one point, all the laws affecting religious groups were those affecting religious minorities, Native Americans, Seventh-day Adventists. But today, as our society becomes more secular, we will start seeing more laws affecting what have traditionally been mainstream religious groups, saying that, you're required to provide, contraceptives in your insurance plan, even if you don't wish to. There's been a serious reversal of fortune, so to speak, of how the courts approach this. So now, because the First Amendment was basically gutted by Smith, RFRA is all that's standing in the way. We'll discuss RFRA more later this semester, but I would not be surprised in our lifetime if the statute is repealed, because people don't like very much now when various groups get exemptions from generally applicable laws. I don't think RFRA is long for the world. States will start repealing it soon. Just watch.
So how can we put a limit on this in a country like the United States where there are three different religious groups? Somebody can say Thursday is my holiday. This place is burning. So how can the law resolve this?
So the court, we'll do this later, but the courts don't question whether someone's belief is, they don't question the doctrines of someone's belief. So does anyone know about the Church of the Flying Spaghetti Monster? You want to tell me what that is? Yeah.
So it is supposedly an actual religious organization. It's kind of made in great satire that they worship this flying monster of spaghetti up in the sky, and they want all the normal religious benefits and freedoms and exemptions and such under the law that any recognized religion.
Right. So it's a doctrine, and I won't use the same language you did, but it's a doctrine of faith that a lot of people now adhere to. And one of the core tenets is that their deity is basically a flying spaghetti and meatball monster in the sky, and that their symbol of worship is wearing a colander, like a pasta strainer on their head. And their thing is that they want to take driver's license photos with their colander on their head. And you have cases where, people want to wear various head coverings for religious purposes in their driver's license photo, and the courts give exemptions to wear a hijab, whatever, in your driver's license photo. So their thing is to try and sue states so they can take their driver's license picture. Now, if you say it's satirical, I'll leave that judgment to others. But again, it's a belief that people adhere to. Letting them wear the colander in their head, doesn't really bother anyone. So the courts have actually let that go forward. But it's, we do have a lot of different beliefs. The other interesting aspect is after the, of course, Hobby Lobby decision, you have now the Church of Marijuana, who their sacrament's pot. and they're attempting to get various licenses they can use marijuana in contravention of state law. We'll do this later. It's a fun topic, but I want to make sure you get the Section 5 point first. So, any questions about Section 5? I mean about the meaning of the Constitution. Okay. In the process, though, in the process of discussing this in Boerne, not just about what the meaning of the First Amendment is, but the court also introduces a new concept. Okay, this is the important part. It's not just that the court is the only one who can define it. The court discusses when can Congress waive a state's sovereign immunity. Recall that underlying this case, Archbishop Flores was suing Texas. Can Congress waive or abrogate sovereign immunity? So the discussion is, when can Congress waive or abrogate state sovereign immunity? So we read Hahn v. Louisiana as establishing that states have sovereign immunity under the 11th Amendment. That's what Hahn said. It's almost certainly wrong, but Hahn said that states have sovereign immunity under the 11th Amendment. Okay? What Boerne v. Flores says is that Congress can waive a state's sovereign immunity. Why? The 14th Amendment came after the 11th Amendment. Under Section 5 of the 14th Amendment, Congress can waive or abrogate a state's sovereign immunity. Look at Section 5, right? Section 5. The court puts forward a test that I'm sure when you read it made absolutely no sense, but hopefully I can shed some light on it. The test is what's known as congruence and proportionality. Okay. Congruence and proportionality. What the heck does that mean? Right? What does that mean? What congruence and proportionality suggests is what we call fit in constitutional law. Fit between the means and the ends. And let me give you an example. Okay. Let's say there's a pattern of behavior of state officials imposing a literacy test. Okay. It happens, right? This is part of American history. You have state officials imposing a literacy test before voting can occur. Congress passes a law saying that, wait a minute, a literacy test is a violation of the 14th Amendment and the 15th Amendment also, the right to vote. We will allow individuals who are given this literacy test to sue. Right? You can sue. That way, the federal government is not responsible for checking every local, county of how they're administering it. If I live in a county where they're giving a literacy test, I can then sue my county official. So what is the end here? The end's eliminating literacy tests. Okay. What is the means? Suing person administering literacy tests. Okay. There's a pretty close connection, if you will. There's a pretty close fit between wanting to end literacy tests and suing the person who gives them out. We would say that there's a congruence and proportionality between the means and the end. There's a congruence and proportionality between the means and the end. Right? As a result, in this case, Congress can waive a state's sovereign immunity. Right? So the question is, when can Congress waive a state's sovereign immunity? When the means are congruent and proportional to the ends. Congress can waive a state's sovereign immunity and allow it to be sued in court when the means they are using is proportional to the ends. Okay, everyone with me so far? So let's look at this case. Let's look at Boerne, right? So in Boerne, what are the ends? Well, under the peyote case, what can Congress do? they can eliminate intentional religious discrimination. Right? This was the holding of the peyote case. Congress can eliminate intentional, and the key word is intentional here, intentional religious discrimination. Okay? What are the means? Sue state official for denial of zoning permit. Well, there's no evidence whatsoever that, run-of-the-mill zoning disputes have anything to do with religious discrimination. In fact, this law is much broader. Under RFRA, you can sue anyone for anything. Under RFRA, you can sue any state official. That is too broad. There is not a fit, okay? There is no congruence and proportionality in the means and ends. Therefore, Congress cannot waive Texas sovereign immunity. Don't mess with Texas, right? There is not a congruence and proportionality there. There's no fit. The thing that Congress can actually eliminate is so much more specific than this broad power to drag a state into court whenever they deny a zoning permit. Yes. Well, he sued the city of Boerne, which is a subdivision of Texas. The city of Boerne is a subdivision of Texas. It's part of Texas, right? So it's one and the same. Whenever you see a city of Houston, city of San Antonio, city of Boerne, just pretend that's Texas. Okay? Houston, as I said before, Houston is nothing. If tomorrow the state of Texas wants to abolish the city of Houston, they can do that instantly. There's no requirement that states have cities. You can have one big state with no city, and that would be perfectly constitutional. Zach?
So I understand the holding, but the images look like that they did remodel and renovate the place to make it look like it accommodates more people.
But they may have done it without demolishing walls.
Okay.
They didn't get a permit to do it.
Okay.
But everyone get this part. When you're understanding, this is probably the more rigorous aspects of the entire class, so I want to make sure you get this. When you're deciding whether Congress can waive a state's sovereign immunity under the 14th Amendment in Section 5, you need to address what are the means and what are the ends, and is there a fit between them? This is not a precise test, right? This is not like, the 4 elements of a battery, right? Whatever they are. This is very, very open-ended. And the court, as we'll see in a minute, has taken a very disparate approach to this. But what you have to understand is, what are they trying to achieve and how are they getting there? And how close is the fit between them? Okay. Everyone with me so far? Yes, sir.
I'm a little confused. So, in what instances would you use the things and means and ends test?
When a Congress is trying to waive a state's sovereignty.
Just in that.
It's a big one, though, right? When Congress is trying to allow a state to be sued, you need to go to the means and ends test and the congruence and proportionality.
I'm assuming it's just a majority of Congress.
I'm sorry?
I'm assuming it's just a majority of Congress. That's like on that.
And, I mean, a law goes through with majority of both houses and the president. I mean, like all laws. Was that your question?
No, it was whether or not. Never mind.
Sure.
Yeah.
What's the difference between this and then necessity test? I feel like what I have here for necessity is that it's kind of like the same thing that the means needs to be in.
What necessity test are you talking about?
In fact, in Hamilton did this necessity for.
It's my Alexander Hamilton?
Yeah.
Oh.
Like it seems like kind of the same thing, that it's very like.
Where are you reading from Hamilton? Maybe I'm not following.
When in Maryland.
You're from McCulloch, Maryland.
Yeah.
Oh, what a good question. Okay, very good question. Okay.
Like, what's the difference?
Thank you, guys. That was an excellent
Sorry.
question. No, I figured out that's improper. So, in McCulloch, Maryland, right? In McCulloch, Maryland, we analyze the necessary and proper. And what Chief Justice Marshall said, as did Alexander Hamilton before him, is that Congress can pass laws that are convenient to the federal power. The Constitution says nothing about whether Congress can charter a bank. But it will be helpful for Congress to have a bank in order to regulate commerce and coin money. So what Marshall wrote in McCulloch v. Maryland was that Congress can pass laws that are convenient to the federal power. Those laws, however, did not intrude on state sovereignty. Those laws did not waive state sovereign immunity. Okay, now, let's go back to the 14th Amendment. You'll recall in the reading, if you don't, you should read more carefully, that in the first draft of the 14th Amendment, Representative John Bingham used the phrase necessary and proper in the 14th Amendment. That would have been very broad. That would have given Congress the power to do just about anything they wanted. That was rejected. And in the place of necessary and proper, the court put the word appropriate legislation. Appropriate legislation is more strict. Appropriate is far more narrow than necessary and proper. So the scope of laws they can do in necessary and proper is like this, and under the fifth, Section 5 is like this. It's much smaller. And what the court said in Boerne is who gets to decide if it's appropriate? We do. The court said we get to decide what appropriate legislation is. And if we deem that the fit is not tight enough, that it's not congruent proportional, then that law is unconstitutional. Answer your question? Other questions on this? Make sure you go back and you pay attention to this because it's actually a very tricky topic that most law students will never actually understand. I didn't understand it when I took ConLaw. Yes, sir.
It seems like a pretty arbitrary distinction that appropriate is synonymous with proper.
Well, it's not. They're saying it's not. They're saying that appropriate is far more narrow than necessary and proper.
Right, I'm saying, isn't that an arbitrary determination? Since in reality, they are synonymous, being proper and being appropriate.
Well, they're not because of the history of the 14th Amendment. In fact, the phrase necessary and proper was in the first draft, and Congress objected because they thought it gave Congress too much power. So they deliberately chose a word meant to give Congress less power. So I think it is arbitrary for sure, but at a minimum, appropriate gives less power than necessary and proper does.
On this, the congruence and proportionality test, is that a test? I know it's a test for state sovereignty, whether Congress can compete on that or not. Is it also a test to determine if legislation is appropriate in all situations on the 14th, or is it just strictly limited to?
So the congruence and proportionality test has been interpreted to apply to Section 5 of the 14th Amendment. There's a decent argument to be made that should also be applied to Section 2 of the 13th Amendment and Section 2 of the 15th Amendment, which both these were appropriate, but the court hasn't gone that far. I've made that argument elsewhere, but the court hasn't gone that far. That's another hand. All right, so let's walk through some examples of how the court has interpreted this Section 5 power. Okay? What you have to remember also is against the backdrop in which these cases were decided. This was a so-called 90s federalism revolution where the court under Chief Justice Rehnquist was trying to figure out different ways of enforcing provisions of federalism. So the first case that's mentioned in the notes is Kimmel versus Florida Board of Regents. So there's something called the Age Discrimination and Employment Act. So if a private employer discriminates against someone for being too old, they fire someone for getting too old, the private employer can be sued. But what if the employer is the state? Right? What if you're working for the state and they fire you because you're too old? Can you sue the state in federal court for a violation of the federal age discrimination law? And the court held the answer is no. Okay? Congress lacked the power to allow a state to be sued for age discrimination. The reason why we'll see later is that discriminating on the basis of age isn't really a big constitutional deal. I'll give you an easy example. Some states allow you to get a driver's license at 18, some states at 17, some states at 16. Could a 16-year-old possibly sue the state of New York saying, I want a license now I'm 18? Of course not. There are rational reasons why you treat younger people differently. So constitutionally, there's no problem with the age discrimination in this factor. So the court rejected that claim. We'll do age discrimination in a couple weeks. The next case from 2001 Board of Trustees of the University of Alabama versus Garrett. This concerned the Americans with Disabilities Act. So if your private employer fires you because you're disabled, you can sue him. No problem there. What if you work for the University of Alabama state and you're fired because you have a disability? The court held again that there's no congruence and proportionality. Okay? A state cannot be sued. Why? Because there's no constitutional discussion about disability discrimination. Right? If you discriminate against someone based on disability, that's not a constitutional violation. So again, Congress is trying to make substantive constitutional law. They're trying to redefine the Equal Protection Clause. They cannot do that. However, the one case where it was allowed, this was probably one of the biggest cases of the entire Rehnquist Revolution, was in 2003. Nevada Department of Human Resources versus Hibbs. This case concerned FMLA, Family Medical Leave Act. Under the federal law, if you become pregnant or some other disability, you can request up to 12 weeks of unpaid leave. Not paid leave, unpaid leave. What happens if a state denied you this leave? Well, if it was a private employer, you could sue for your 12 weeks of leave. What about the state? Could you sue the state in federal court for denying you your medical leave? And a decision by Justice Rehnquist, and this came as a surprise to many, Justice Rehnquist held that yes, you can sue. Why? Chief Justice Rehnquist wrote that this law of guaranteeing medical leave was aimed at eliminating gender discrimination, and that one of the incidents of gender discrimination is that women could not exceed in the workforce if they had to basically quit their jobs to become pregnant. So the court upheld this, finding there was a congruence and proportionality, right? The issue of gender discrimination was closely linked with the ability to sue for damages the state for not giving this form of marital leave, pregnancy leave. So in Hibbs, the court found a narrow tailoring that only affects the employee-employment relationship, and that was permitted. Everyone with me? Eric. Hibbs, turn Hibbs. Boerne, yeah.
So I'm confused between these and how
In Boerne? Boerne allowed a lawsuit against any state official for any reason, even if there was no absence, or even if there's no proof of intentional discrimination. The reason why there wasn't a good fit was because the Constitution only allowed Congress to police intentional discrimination, not this general, you're burdened by religious, by the law. Make sense? So when you're doing these questions, there's not a particularly clear line. But we know for sure is that in Boerne, the problem was the government was trying to redefine constitutional rights, and there was no fit there. On the other end, you had Hibbs, and in Hibbs, the court said there was a close enough fit because gender discrimination was closely tied to the denial of family medical leave. Not a particularly straight line. And these cases are very difficult to reconcile, but that's the basic rule. So any questions on Boerne, on Kibble, not Kibble, on Hibbs, on Garrett and Kimmel? They merged when I said Kibble. Kibbles and bits, right? Any questions? All right, let's move to the last case. United States versus Morrison. We already discussed Morrison when we did the Commerce Clause. So you recall we did the Violence Against Women Act, VAWA. And the Violence Against Women Act was meant to create among other things, a lot of things, but it meant to create a private cause of action, that if a private individual engages in an act of gender violence, you could sue them, okay? Under state law, if someone commits a battery motivated by gender or whatever, you can sue them. But historically, there had never been a federal cause of action to sue someone for a simple gender violence. That had not been a crime. So the first aspect of the Morrison decision considered whether the Commerce Clause could be used to justify this law, and the court held no, it cannot. That an act of domestic violence is local. It is not economic activity. And under the holding in Lopez, because it's not economic activity, you can't regulate it under the Commerce Clause. So the first part of Morrison we already did. You cannot bring a cause of action based on gender violence under the Commerce Clause. The second cause of action, though, was based on the 14th Amendment. Congress didn't just rely on the Commerce Clause. They also relied on Section 5. So what VAWA did was saying, if you are engaged or you are the victim of some sort of gender-based violence, you can sue whoever does it to you. And what happens if the state is the one who is involved in an act of violence? VAWA says you can sue the state in federal court. As soon as you see a question about being able to sue a state in federal court, this should tell you, okay, we're in Section 5 land, right? So the issue becomes this. This is Christy Brazoncala. She was a student at Virginia Tech. And in case you didn't realize this, Virginia Tech was a state institution. When you sue Virginia Tech, you are actually suing Virginia. Okay, they're all subdivisions of the state. There's no difference between Virginia Tech, University of Virginia, whatever it is. I went to George Mason, it was a state school. Virginia, these are all state institutions. So Brazoncala accused two football players of raping her. She stopped attending classes. She withdrew from college. One of the players, Antonio Morrison, was suspended from the team for 2 semesters, but that was later set aside. He claimed to have an alibi. And the other player, James Crawford, as best as I can tell, nothing happened to him. So I actually researched this. A grand jury in Virginia refused to indict Morrison. They claimed that because of the alibi, they wouldn't indict him. Again, this was a football player in a pretty big football town. So because the state court system did not provide any sort of remedy for Ms. Brazoncala, she brought suit under this new federal law, this Violence Against Women Act. And she didn't just sue Morrison and Crawford because they were basically broke college students. I looked this up. Neither of them made it to the NFL. One of them dropped out. The other one disappeared. I couldn't find what the hell happened to him. But these guys did not make it big. She sued the school. Why? She claimed that the school, through their flawed disciplinary process, was complicit in this violence against her, and that they did nothing to punish these individuals who were accused of these actions. Okay. So she was suing the state. She was suing the state for gender violence. All right. So what's up to? Anna. So what happens here? What does the court do with her claim that the state ought to be sued for violating her rights?
What do you mean?
Do they allow her claim to go forward? Does the court allow her claim to go forward?
They adopted the Supreme Court's definition of gender discrimination, and so they looked at the congruence and proportionality as well.
Okay, so how does this case shake out under the congruence and proportionality test?
Okay. They said that they could do this, that Congress could take this case.
I think you're a little confused. What? Let's walk through this, okay, Anna. What was Congress trying to do with this remedy? What was Congress trying to do by allowing Christine Brazoncala to sue the university? What was their goal?
It was to keep the private person, like, control, or ask the private person within there.
Right, but it wasn't just private persons. Who is she suing here?
The state.
The state. And what's the significance of suing the state? But why would it be considered a bad idea, or perhaps historically a not popular idea for anyone to sue the state? Delaney, let me ask you a question. Does VAWA prohibit discrimination by state officials? Is VAWA aimed at stopping state officials from discriminating against women?
No.
It doesn't. What does VAWA actually do then?
All people.
Okay. So it's somewhat regulating private conduct. We're not concerned about that. But what is it going after Virginia for? What exactly is Virginia's fault in this case?
We're not taking action.
Okay,
For the state, they will not take action.
good. So what the court says here, right? What the court says here is that VAWA is not about remedying. It's not remedial. It's not trying to fix constitutional violations. No one alleged that the constitutional right was violated here when this girl had this happen to her. Okay? No one was alleging there was a constitutional violation. What VAWA was attempting to basically do was to reach conduct that was not unconstitutional. VAWA was attempting to give people the right to sue even though their state officials did not violate the Constitution. VAWA is directed at the individuals who engage in the act of violence. Okay? It does nothing to the people actually involved in investigating her case. So imagine a different law, right? Imagine this law. Congress said, if you are a state official and you fail to adequately investigate rape allegations, you just ignore rape allegations, you can be sued. John, what do you think of a law like that?
Sounds awful.
Sounds awful?
Yeah, but they're not also being responsible. Or,
No, would that law be constitutional?
oh, it would be constitutional.
So the law's like this, right? The law says, if you are a state official and you fail to properly investigate allegations of rape, you can then be sued by the victim of that crime. Could Congress enact that law?
No, it's specific to the individual, right?
Well, it says specifically, if an official does not investigate credible allegations of rape, then the victim could sue that person. Could Congress pass that law? Why are you saying no?
It reminds me of the case with the sheriff case with the Congress trying to enact the statute for state officials to.
Oh, no. But be very careful.
Okay.
The law does not say you're required to investigate anything. All the law says is if you don't, you can get sued. Ah. What test would we consider, John, to understand this question? So what are the ends, right? What's Congress trying to get at here?
Prevent sloppy interrogation.
Oh, no, more. Prevent gender-based crimes, right? Prevent gender-based crimes.
And the means would be to, prevent sloppy interrogation.
Would a lawsuit encourage an official to investigate thoroughly?
Yes.
So would there be a congruence and proportionality there?
Yeah.
Okay. So at Congress, and this is basically what Title IX is, by the way. This is a federal law. I'm not making it up. But if a state official fails to properly investigate a gender-based crime, and Congress said you can sue for that, that's one thing. But VAWA didn't say that, right? VAWA had nothing to do with the individuals. You're not suing the coordinator of the school's investigation thing, right? You're suing the state itself. You see, the fit is weak. There's not a close fit between the means and the ends. The end is you're trying to eliminate gender-based violence. Okay, that is within Congress's power. But the means you've chosen to get there is not to sue the people involved, but to sue the entire state, right? To sue the entire state. Because the remedy is not narrowly tailored to the end, Because the lawsuit is not narrowly tailored to the goal of eliminating gender violence, the court found is not congruent proportional. Therefore, Congress cannot waive Virginia's sovereign immunity. Therefore, this provision of VAWA was unconstitutional. Everyone get that? There was not a close fit between the means and the ends. The end of eliminating gender violence and the mean of suing the entire state, regardless of who is involved, that is not narrowly tailored enough. Okay. Everyone get that? The court. Oh, sorry. Yes, yes, sir.
I get that, she may have been suing the entire state over it. Is there a way to sue a government institution like I am just suing Virginia Tech? I don't care about the people.
No difference.
There's no way to create a division between.
No, and see, that's the point. This is why I made this point very clearly to start class. Virginia and Virginia Tech are the same thing, right? Virginia and Virginia Tech are the same thing. Houston and Texas are the same thing. Virginia Tech only exists at the leisure of Virginia. So the actual initial name of the case was actually Berzoncala versus Virginia Polytechnic University. The actual case, when it gets to the Supreme Court, the names get jumbled up. But the actual case was Berzoncala versus Virginia Polytech. She did to the university. But the issue here was the statute itself. Because it opens the entire state up for damages, that is what made it unconstitutional. Make sense?
So if the statute had said you can sue the institution
within
that,
but
or a
official. Yes.
Official.
So that's why when you're suing an individual, it becomes much more specific. Whereas Virginia Tech as a university is an arm of the state. The University of Texas at Austin is an arm of the state. University of Houston, we're in a private school, but everything else is an arm of the state.
So is that what a lot of your cases like it's NFIB versus Sebelius or Carey or whoever's the
exactly time. Although there was also Florida versus the HHS, was also a state involved as well. Another hand somewhere. Okay. And Chief Justice Rehnquist notes at the end that this is a problem for Virginia to fix, not the federal courts. That if in fact Virginia has so fallen down and allowed this sort of gender-based violence to occur, it's not for Congress to fix. He says at the very end, no civilized system of justice could fail to provide her a remedy. Indeed, she got no remedy, as it turned out. So any questions then on Morrison? So we did a lot of stuff today. We had a lot of ground on different topics. But the first major point that I want you to remember is that in light of Chisholm, the 11th Amendment, and Hans, states have sovereignty. Okay? The 11th Amendment, the text notwithstanding, states have their sovereignty. And a state cannot be sued unless it gives its permission. The exception to that is under the 14th Amendment. Section 5 of the 14th Amendment allows Congress to waive or abrogate a state's sovereignty. But as we learned in Boerne, in order for Congress to abrogate a state's sovereignty, the means and the end must have a fit. There must be a congruence and proportionality between the means chosen and the end which sought to be accomplished. Unless this congruence and proportionality is present, Congress lacks the power to waive a state's sovereignty. And then the state cannot be sued. Okay. Questions? Yes, sir.
So when you sue a state under a statute where Congress waived their immunity, you have to accept what Congress said the end was, and you say, here's what it's actually achieving.
So what's interesting about this is in Boerne v. Flores and in Morrison, the United States intervened in the lawsuit. And the Department of Justice actually argues what the U.S. interest is. You don't get to do that, as well in both in Boerne and Morrison. Questions? Yes, sir.
You may have already touched on this, but if she were to have gone to a private school and sued for the same thing,
She could have done it.
she could have done it and stopped it in the private school and
Yep. But when you go to a state school, Chisholm and Hans say states have sovereignty and you can't sue them. Different rules apply when you're working for the state. Anything else? Okay, have a wonderful day. Thank you all so much.